Uh, Good day, classmates. Good day, Judge Ongkeko. Here I'm going to present to you my video blog about Article 82 and 83, Family Code of the Philippines, Title 4, Property Relations between Husband and Wife. Article 82 says the nations by reasons of marriage are those which are made before its celebrations in consideration of the same and in favor of one or both of a future spouse. These donations are governed by the rules on ordinary donations established in Title 3 of the Book 3 of the Civil Code insofar as they are not modified by the following articles. The requisites of donations propter nuptias, or before marriage, donations before marriage is in order that donations propter nuptias may be valid, the following requisites may be present. Paragraph A, they must be made before the celebration of the marriage. And paragraph B, they must be made in consideration of the marriage. And paragraph C, they must be made in favor of one or both of the future spouses. So donation propter nuptias are governed by the statutes of fraud in Article 1403 of the Civil Code, as they are agreements based upon the consideration of marriage other than a mutual promise to marry. Hence, to be enforceable, it must appear in writing pursuant to the statutes of frauds. Such writing need not be in public instrument. It will be in private writing. This is true with respect to donations in considerations of marriage, but not in ordinary donations, which require a public instrument and acceptance. Article 749 New Civil Code. So, case at bar here is Pilapel versus Ibay Somera et al. GR number 80-116, June 30, 1989. By Justice Regalado is the ponente. So, this is a special civil action for certiorari and probation to review the decision of the RTC. The facts of the case are, Imelda Pilapil was married to Eric Jilling in Germany, and their marriage bore one child. Jilling eventually filed for divorce in Germany, stating that the causes of failure of the marriage. Petitioner then filed an action for legal separation, support, and separation of property before the RTC Manila. After the promulgation of the divorce decree, Jilling filed 2 consecutive complaints of adultery against Pilapil for having relationship with Chia and Chua. She asked the court rather to have her arraignment deferred, but to no avail, as well as the motion to quash due to lack of jurisdiction. A temporary restraining order was eventually issued for him to him from the implementing said order. So the issue here is whether or not a criminal case for adultery which took place after a divorce is barred by the previously acquired decree of divorce. So it was held by the court. The court ruled in affirmative side. This was based on 2 concepts. First, that the Civil Code of the Philippines recognized a divorce acquired by an alien spouse in another country, provided that it is valid based on his national law. The second concept is that adultery requires an offended spouse, which means that marital status is relevant. In the case at bar, Jilling divorce decree acquired in Germany is recognized in the Philippines, freeing him and Pilapil from their marital bond and responsibility. Since they are validly divorced, Jilling cannot be considered an offended spouse, considering that Jilling is already divorced rather. So, to file an adultery case against Pilapil, who had then the right and freedom to enter into another relationship. So that's my report. Thank you and good evening, ladies and gentlemen.